Why? Pass on the memo. Yes.
Item number 1.
For a week. Oh, you're adjourning for a week. We are not recording anything, simply adjourn for a week.
One request is also that position will be maintained.
Sir, this is item number 1.
Sir, that's
Yes.
only
The interim order will be extended, and I am signing another principal content that is in spite of your lordship's direction to restore.
It will be listed today, interim order will pass.
No, it will not let it come on that day.
It will be listed today for some other reasons and order will be passed. Cannot take up the
That matter is that is not the probably your lordship.
There is some predicament.
We understand.
I understand.
Can't take up the matter. So it's better. We are not passing any order today. It's simply
All right.
adjourned for tomorrow.
All right.
Come.
Item number 2.
This is whose order? And
My lord, this matter may be after lunch. Mr. Senior Advocate.
okay. Which order is under contempt?
My lord, this matter I pray for after lunch, madam.
That you can.
Mr. Surya Prasad, Mr.
No, sir, this can't be done in this way.
Here we have, last time we had given a direction to the collector to file the affidavit.
Yes, they have filed the affidavit.
File the
They have filed the
Today.
affidavit.
Today.
No.
We are filing a compliance affidavit.
No, compliance affidavit has been filed today.
It has not come on record and filed.
That is what I say.
My lord,
Not
may
record.
I pray October at least.
Collector filing, compliance. That's all.
2 p.m. he wanted. 2 p.m. File it.
Fine.
Item number 3.
Number 3, the direction for compliance of the order passed in the writ appeal. We have already complied with the order as per direction number 4. And we have already joined in the service and backwards we have paid. Now we have to submit a blank check, cross check, so that
For the remittance directly in the account.
account.
That is what is now system is.
Yes.
You'll have to give
I don't know.
cross check,
Cancel
cancel check, so that they can instruct the department. So all money onwards will be credited in your account.
Only
Why don't you give it?
that I will submit today, my lord. I will submit.
Give it.
And second thing, my lord, the order they passed, my lord, looking at the compliance, my lord. Kindly see for a moment. They passed an order fixing the scale of the petitioner up to 2018, when petitioner was terminated. From 18 till 2026, when he was reinstated, that order has not yet been passed. Though direction was given. That may be.
That will be looked at the officer.
Which one? Where is the order?
After termination.
Order is,
Where is the order?
yes, sir.
17/7/26.
That order is at page.
Where is the direction?
Page 20 of compliance.
Huh? No, this is the dismiss.
Compliant by
It's a written.
order.
Then why the contempt is before us?
Contempt application was disposed of on the basis of the statement of the state government, my lord. I, with a liberty to.
No, sir. There are one thing. That's why I am asking. This is a writ appeal, and the writ appeal was dismissed. Simpliciter.
With the direction to comply.
Simply extending the time to comply.
Comply.
Why the content will come to the division bench? I am asking you. Why not? It will go to a single bench who passed the order.
Since direction was.
My own judgment, a special bench judgment of mine over there.
Since direction was given to.
No,
comply.
sir. Doctrine of merger in that sense will not apply. Read Gojar Brothers' judgment of the Supreme Court. it will not lie to us why it has come to us.
That has been disposed of, content has been disposed of.
Why it is being listed?
Now he's coming.
Content application has been disposed of. with a
So you have come in IA.
IA.
Why?
What for?
For revival in view of the liberty given by this honorable.
All right, but
What liberty?
Liberty was given while disposing of the content. In the event that order has not been complied, we file an application for revival.
Writ appeal, there is modification of the order imposing cost of 50,000.
yes, has it been complied?
Yes, that we have complied with.
So the only aspect
Only
is the
aspect is-
period of termination, beyond termination, 18.
Right.
That period will be looked into the matter, or the district will look into that. Everything has been covered, they are joined in the service.
Still
He
you
now
put some
continuing
thought.
only after submitting, wages should be paid to him, monthly regular salary will be paid to him. In course of the day,
Your cancelled check has to be given.
Cancel check will submit in course of the day, my lord, for release of current salary. But so far as this order is to be.
So why to precipitate it further? Because why to precipitate this particular contempt further? Because substantially it is complied.
Substance.
And the pay scale which has already been fixed has to continue even beyond the period of that, because that has been set aside.
My lord. That is to be only, that part is to be, they have to comply from 2018.
Where is the single bench order?
My lord. In read appeal,
8 weeks time must be.
But I think there is a single bench order where the direction has been. The appeal is here. Order, yes, we'll do it. This 70.
the operating part. There's para 20 plus.
Yes, to grant him all consequential service and financial benefits. So that is what is there. So we'll have to give, if there is any enhancement in the scale of pay, then we'll have to adjust it and do it.
That is about it. Yes, the direction is.
Direction is quash the order dated such and such by the collector disengaging the petitioner from service. Opposite parties are directed to reinstate the petitioner in his posts and grant him all consequential service and financial benefit applicable in law.
Yes.
So from the date of the reinstatement.
That part of refer to the government for clarification, whether he has not worked for that period, whether he will.
Why not the back wages cannot be granted from the day
Back was
of
because of the-
reinstatement?
in another case, because of the employment of passed by this honorable court, his service was terminated.
Whatever it has
That's got-
gone and the division bench has affirmed, then
That
we'll have to
order-
give all financial benefit.
So assuming the grants from time, the meantime will take a decision on commercial laws. That was not refer to the government to take a decision. Will come.
The service of the petitioner was this.
Item number 4.
What is this contempt?
This matter, if the state has gone in appeal to apex court.
Yes. What has happened?
Now matter is gone to apex court.
Give me a number. Give me a number.
Numbers have already went to the council, appearing the state council. The number we have not received.
When the instant contempt application is taken up, it is informed by the they have gone to the
Terms of the IIC and the SI.
Item number 28.
Yes, calculation.
You know,
28 who is appearing?
28 cancellation of registration.
Sorry, 27 who is appearing?
Malus 27, I am appearing for the CGST matters.
Okay, that's it. RC cancellation. Yes, next, 28.
Item 28.
So item number 28 may not be covered by that order. Okay, let's see, this is cancellation of RC for non-conducting business in the declared place of business.
Non-conducting?
Business in the declared place.
Okay,
of
at the
business.
declared place.
So he has not filed any evidences. So let him file one additional affidavit and he permitted to take it.
The prayer of the principal, complete time is given to file an additional affidavit. Sure, place of business, no problem. 29.
Item 29.
17, 74, 73, 73 for fourth August. Huh? Hearing has started or not?
No, my lord.
Item number,
Jones and Adai.
item 30.
Cancellation of RC.
Yes. Cancellation. Sorry.
Item number 31.
Let appear for Mr. S.K. Joseph, reading the item number 19.
No, I don't 26, matter.
Maybe it's the problem.
32.
Yes.
You give the appellant before your lordship. The forest
Your
fire.
order,
Yes, my lord.
which is the impugned order?
7/5/26 at
Just
page
first
7.
give me 30 seconds time.
Yes, ma'am.
Small matter than the document shows that that you joined on 14/8. It's a question of 3 days. I understand in between 3 days, some persons have gone above in the gradation rates. So where is the document showing that you have joined on 11/8? Where is the document?
Submission before your lordship is that this has to be counted from the date of appointment. That is my first prayer.
No.
In the
What is the rule? You tell
Yes.
me that rule says from the date of the
Yes.
appointment letter or from the date of joining?
date of appointment. My lord, kindly have a glance to the read petition.
You did not argue this point before the single mail.
21. No, my lord, I am
Then?
not done.
So you are taking this point here.
My lord, kindly have a
Show us,
glance.
show us, show us.
21 to 23. The
20?
notification. The notification. 21 to 23. 20. It starts with 20
21 to 23 what?
of read petition, my lord. But
It is not before me.
my lord,
Anyhow,
my lord, that is
will
2000.
you not annex? Those are the important documents. Will you not annex with this? At this interim application you are filing, will you not annex?
My apologies, my lord, I got the read petition.
No,
Yeah,
you thought.
Your read petition.
Yes, what is this?
My lord, that rule, 12(3) rules. That is also in the Odisha Forest Manual, my lord. Can I hand over this? My lord, can I hand over this? My lord. This is Odisha Subordinate Forest Service Method of Recruitment, Conditions of Service of Forester Rules. That is 12(3). 12(3), my lord.
Yes.
12(3). Rule 12(3), my lord. For promotion to the post of forester, a common gradation list of all the recommended eligible forest guards of different divisions under a territorial circle shall be prepared by the RCCF of concerned territorial circle, basing on the date of their appointment in the concerned division.
Madam, this is what the amendment having got in the year 2021. You
Yes,
are in
sir.
2020. You joined in 2009.
Yes, my lord.
Can we consider this aspect? Can it have a retrospective operation?
My lord, I bow down, my lord, but the gradation list that which is under challenge, that published in the year 2023, which is under challenge, my lord. That is for that reason, I espouse this cause before your lordship.
Give me a book.
Yes,
And that
Space.
has come in 2021.
yes, my lord. 21, and this gradation is
Yes, sir.
23.
Yes.
23. That is at annexure 7, page 23.
Yes.
The rules while preparing a gradation list after 2021. I understand this is what you wanted to say, but the problem is the thing which has already been done at the initial stage. This is not a gradation list for the first time coming.
Yes.
There has been a several gradation lists prior to 2021 published by them inviting an objection where your position has already been shown there.
Yes, my lord.
In that event, you did not raise any objection to it.
My lord, this
Now-
rule was not before.
Now the difficulty is that many water has already flown in the
My
meantime.
lord, I bow down.
Many persons have already been promoted on the
But
basis
my-
of those
this-
gradation.
This
Will
rule,
it be advisable? I think
My lord,
we
this
must
rule-
have a prospective operation.
yes, my lord. In
Prospective in the sense that whatever the gradation, earlier gradation list is there, any new entry
Yes.
that would be done in accordance with the sub-rule 3.
Kindly have a glance.
Entry in the
My lord, kindly have a
service,
glance.
not
My lord, kindly have a glance to the gradation list, which is under challenge over here. That is 2023, my lord.
Madam, probably, I think I could not start this a wavelength with you.
Yes, my
Please
lord, I bow.
consider what we are saying. You are coming because now the last gradation list is published in 2023
Yes, my lord.
after 2021 notification by which this rule sub-rule 3 or rule sub-rule 3 is introduced. But the difficulty is that prior to this gradation list last, many gradation lists since 2009 is published
Yes.
because your joining date is 2009, either 11/8 or 14/8, but of the year 2009, right? Draft gradation lists were prepared, objections were invited. After the objection, final gradation lists were prepared. On the basis of the final gradation list, many promotions, many incentives, many things have already been done. And this says that this amendment will take effect only after the notification in the official gazette, that is a 2024. So if it is to be given a retrospective effect, it will upset all the gradation lists or invite all the revision of the gradation list which achieve finality and also the actions have been taken thereupon. If it is to be taken prospective, then whoever enters after this notification of 2020 or 2025, they will be suitably placed in the gradation list.
My lord, if I'll
This
say-
is what our
Yes, my
impression
lord.
is.
Yes, my lord. That I totally understand, my lord.
So,
But my lord, if I say कि they have implemented this rule in the gradation list because there is a clause, my lord, in the rule where there will be a date of appointment will be same. Then
that is a proviso I know. When
yes, my lord, they have corrected that. They have corrected. My lord, kindly have a glass. That is the my argument before your lordship. Because if they
you
have
have not
corrected,
made out any case, you did not argue all those cases before the single bench.
my lord, the honorable single judge has not touched that issue at all. My
Where
lord.
you have made out a case of such nature,
My prayer kindly have a glance.
you
to
show
the
me
prayer.
your pleading of the writ.
My lord,
Petition
opposition party number 1. My lord, my prayer. I am reading out the prayer. To
Let
issue,
us see application, what case you have made out.
my lord,
Let us see.
to issue the press.
No, just
release.
see what case you have made out. I am reading your writ petition. Give me 2 minutes then.
My lord, at para 4.
Just, I am reading it. Second paragraph says, no, it should be 7-8.
7-8.
You do not know, you are not sure that whether it is a 7-8 or a 11-8.
Is it my?
See, by
Is my lord.
Paragraph 8, 9, everything you are,
My lord,
which organization?
appointment and joining
Forest.
as 7-8 to 9.
Forest Department. my lord.
Notice. Returnable after 4 weeks. Yes.
Both of this is one. Both of this.
Interim order in this. What interim order? Unknown. In these cases, any interim order can be sought for. Let me see that what you have prayed for.
My lord, only one post to be given back.
Sorry, nothing. Yes.
There is a recent judgment also because substantive justice.
Next
My
question
lord,
is
notice.
33.
May I pray?
33.
My lord, may
There
I
are two
pray?
matters.
2 matters.
Yes, my lord. In 32, 2 matters.
Notice.
My lord, may I pray in interim IA notice to be
Both. What is it? Both.
read?
33.
To be confirmed. I shall not join.
Yes, two. Yes.
Item number 2. We had filed a complaint affidavit, but it has not come on record. So I'm giving the.
On your ground, the matter was
Yes,
kept
I'm
at
so
2.
sorry. I'm extremely sorry. Because I was held up in the other court. I'm sorry.
What in contempt?
Sir, contempt actually, you are specifically directed the collectors to comply section 24 of the Wildlife Protection Act. But 24, one says that it has to be adjudicated so far as the rights and liabilities are concerned. They have only done that. If you also looks at 24.2.
What is your you want to file a compliance report?
Yes, no.
File it, give a copy to them,
It has already given a copy.
given.
But it has not come on board.
Let it come on board.
I'm giving the hard copy.
Hard copy you give, let it come on board next week, keep it.
I'm sorry, but like you.
No. That's the privilege of a lawyer. What 58?
See, it's a matter. I don't. 8 minutes. There is, I think, there are private opposite parties. Notice on limitation to go. The second party.
So why your junior mentioned the matter to be taken up out of turn?
Had 2 minutes, unless minutes.
He's going, he's saying his house is going to be demolished. Today has started demolition.
No, because the private case, my lord, pursuant to the order of the decree by the civil court, my land has been demarcated. A person who is not a court tenant, he filed a miscus suppressing the land, they are now going. That is the whole problem.
Where is give me a file? 58. Give me a file. 58. Yes.
Very brief, man.
Where is the order?
I'm kind of at the page 20.
Where is the order?
Annexed
Page 20.
Page?
20.
This is the order of a single judge.
Paragraph 5, my lords.
So nothing has been done, simply demarcation. Why you said that they are going to demolish?
Only one line. Perhaps can be referred to demarcation case number 1
No, sir.
of 2025.
Where is that?
But that is para 5.
This is my.
No, this is a demarcation case.
But this is my petition.
Maybe their direction is to consider.
I think I might also appreciate it.
Then where is the question of any demolition?
But can't be just one thing. What is happening? My probably is not able to communicate. My thing is that much the demarcation case is mine.
Huh?
He says that I am the adjoining owner, no, Dr. Dollar adjoining owner.
Whatever.
Without including organization, including the party, got that order.
That's the demarcation. That's the demarcation will be done. Where is the demolition?
No, but that basing upon that, he along with persons wants a tracing on that is my
No, sir, we can't. Sorry. Let it be taken up serially. No. Sir, I have a very strong reservations for this. I tell you very frankly. To on the government.
Yes.
No, just let us first go through the impugned order. Page 20th May 2026 is the order?
Yes, sir. And next
Yes, just 1 minute, give us. The authority was not found to be competent to pass an order of transfer. So you have been reverted back to your original posting. Why you are aggrieved?
That is my case, sir.
What?
But the only thing which is to be considered by your worship is in exercise of plenary powers of this honorable court, can the honorable secretary could have passed a direction as regulating my transfer conditions, fellow. Now,
What is the transfer condition, sir? You were transferred from one division to another
Yes, sir.
by virtue of an order, which order appears to be illegal
Yes, sir.
and cost. What is the consequential effect of that order?
That has never happened.
Never happened.
No,
What you would see, Annexure 18, Annexure 8 and page 31 was the impugned order.
No, that authority has so much to withdraw it.
On the direction of the honorable single judge.
All right.
Sorry, whatever.
Your lordship would
It's not
see-
a, it is, he simply says that once the annexure 3 and 4
Yes, sir.
is cancelled, which is the foundation of the order of transfer, then everybody who has been transferred by virtue thereof has to be reverted back to their origin.
That is not the case. Your lordship may allow me to place the matter of just for your lordship would see Annexure 2. I'll just quickly take my lord to the relevant annexure. Annexure 2 and page 23.
Annexure 3, 4, annexure 4. This is item number
33.
Open the writ petition.
The writ petition has been annexed to your the writ of election. Annexed to 9. Annexure 9, madam.
Writ appeal.
Annexure 9 is the writ petition. Annexure 9 and page 32, madam.
You're referring to annexure
Nine.
9.
Yes, sir.
After the writ petition, then, after the writ petition,
Yes, sir.
annexure.
This is the order. The petition is in the court. This was your transfer order.
Yes, sir. The order which was imputed before the
The
honorable
rate
civil judge.
was issued by a chief engineer and basic manager. He says that I am not a competent person to order a transfer.
No, but that is, your lordship, for a
That
moment.
is what is where
No,
he is a.
Your lordship, for a moment,
Order-
what was the?
In the order, it is recorded that he fairly concedes
No,
that he is not a
because
competent
that,
person.
that was never under challenge before the honorable single judge. The orders which have been cancelled by the.
Whatever be, if the writ petition, while considering the writ petition, found that certain order which is a foundation of a subsequent order is found to be illegal, cannot court set aside that order as well, even if it is not asked for. What is the use of such other order as your lordship may deem fit and proper? What is the meaning of that expression?
The order which was impugned for the honorable single
Sorry,
judge.
we can't.
Moment, Annexure 8 at page 31. Annexure 8 at page 31, that was the order which was challenged before the honorable single judge. This order was passed by the chief engineer and chief pilot. But having obeyed the order of transfer and the posting, I joined at a particular phase. Subsequently, this order comes to be passed under Annexure 8 at page 31. I challenge this order before the honorable single judge. Only the last, your lordship may kindly see the last portion of the input order. I'm agreed by that last portion, madam.
Reverting you back is your problem.
No, madam, for a moment, madam, your lordship may just kindly see Annexure 1, the last paragraph. Paragraph 7, madam, at page 19. Having heard learned counsel appearing for the parties and considering the submission made, it is found that challenging the order dated 21/1/2026, so issued by the opposite party number 2 under Annexure 1, the present writ petition was filed entirely on the ground that on the face of his transfer, while order dated 201 dated 13/1/2026 under Annexure 3 and consequential order passed under Annexure 2, order number 205 under Annexure 4 of the opposite party, the petitioner was allowed to continue in the post of annexures. Subsequently, last paragraph, page 21, 7.3. I'm only agreed by this portion, my lord. 7.3, since the orders available under Annexure 3 and 4 have now been cancelled by orders dated 19/5/2026 of the opposite party number 3, petitioner is directed to join in his previous place of posting under Annexure 4, under opposite party number 4. Opposite party number 4 is directed to allow the petitioner to continue in his establishment on submission of his joining report.
That is what I'm saying, that you are more concerned with your, the reinstatement of your previous.
Madam, this is something which was supposed to be passed in the administrative side, my lord.
Nothing.
But now, madam, your lordship, for a moment, your lordship. But in fact, your lordship, while
The
Constitutional law to follow it.
No postmortem in a
moment election. What you would see, now also same orders are being passed with the same authorities.
maybe.
Item 34.
I think for my paper two, no, I file is misplaced.
Next.
Item 35.
I am applying for response. Plus, it's my date, last term, my last term. Order date is 6/7/2026. 6th July 2026.
Yes, have you taken an instruction?
Yes.
You need to accommodate it? Then everything has to go
But the
on a legal party. We wanted to. When will the same thing cost?
110 persons already are.
Maybe. If there is an illegality, there is an
Appreciate
illegality.
one aspect, Manu. The select list.
Legal party. It is then if we have to set aside the entire recruitment process of 2006, we will.
But that recruitment process on several occasions, these select lists were revised. Matter has been carried to this honorable court, so also to the Supreme Court, and those select lists in 2012.
We are simply on the basis of a reservation having followed by the recruitment committee, whether it is in consonance with the constitutional mandate or the statutory provisions, we have to see. If it does not withstand on the constitutional provisions, then we have no other option.
Well, once the select list has attained finality in 2012,
It's not a question of
can it
select
be
list.
questioned and reopened in 2023?
It's a question of illegality and a constitutional infirmities.
But once the select list has attained finality in 2012, and there is no challenge even before the honorable single judge to the select list, and that pursuant to that select list appointments already made in 2023, can it be reopened merely by filing a representation and pursuant to an order passed for consideration of the representation that was reopened, again challenged in the writ petition?
Again, I'm saying there are a distinction between a right which emanates from a certain statutes and a right which is fundamental and recognized under the Constitution. Fundamental rights, if it is violated, delay and laches cannot be a ground for rejection of the writ. It is a case of a fundamental right being violated by
No, but it is a case where the reservation principles have been applied. But as per petitioner, he says that the horizontal reservation,
how the
process-
Constitution mandates about the reservation.
Well, the horizontal reservation cut across the vertical lines. Now, horizontal reservation, as per the requirement of the rules, it was considered 10% reservation in respect of home guards for recruitment to the post of constable. 10% reservation applied, my lord, taking the entire select list, the vacancies in the entire select list, that is 110, and 11 number of posts were earmarked for the horizontal reservation, that is for the home guards. Now, in that entire 11 vacancies, appointments were made. Subsequently, as argued by my lord senior, subsequently by virtue of an order of the tribunal, the reservation prescribed for the UR category, which was earlier 38, that was enhanced to 56. So, but so far as the horizontal reservation is concerned, 10% of the entire vacancy, that is 11 posts have been rightly filled up. That is what our submission in the counter affidavit also. So 11 posts have been filled up. So now if the petitioner alleges that the reservation, so far as the UR category is concerned, it should be 6 instead of 3, then 3 number of posts which has already been accommodated to SCPC category are to be disturbed after so many years of appointment. So Lordship may kindly appreciate, all the appointments have been given effect pursuant to the final select list, which attained finality after several rounds of litigation, and appointments were made way back in 2012. Now the petitioner, out of the deep slumber, comes out in 2023, files a representation before the authorities, then seeks a direction from this honorable court to consider it. The honorable court directed, yes, his representation be considered.
To file a rejoinder to their counsel.
Yes. As well as the ground, in their counsel, they have calculated the reservation points. The lordship will see from their counter. And in their counter, they have said.
Rejoinder is there on the board.
And one judgment of the Honorable Apex Court. In fact, the Honorable Single Judge would have.
Writ of petition.
You might have filed, not here in writ petition.
Yes, I have filed. I have filed rejoinder also.
Lordship may kindly appreciate this judgment. The Honorable Single Judge would have first appreciated the fact that whether the select list can be reopened, because the select list was never the challenge in the writ petition. If your Lordship may kindly see. Now, disturbing a single candidate would unsettle the entire select list, which has attained finality in 2012, after so many years. And if your Lordship may kindly see this judgment, para 9 to 15. I'm referring para 9. This is on the question of delay, although in writ petition there is no specific period prescribed for delay.
So you are referring a judgment of a party who is sharing a border with this state. No, this time.
Para 9, if your Lordship may kindly appreciate. Having heard the rival contentions raised on perusal of the facts obtained in the present case, we are of the considered.
It is on a delay and laches.
Yes. Here is a case where
Disputes. That is what I'm saying. There is a fundamental distinction in this regard. Had it been another case, the delay and laches plays a very important role in intervening the repetition. But the exception is that if there is a violation or an infringement of a fundamental rights, then the delay and laches will not be a ground for denial of the release. If you want, I can give you plenty of judgments.
If, my lord, assuming for a moment that this is a case of violation of fundamental rights, then he could have challenged the select list, the very select list for the Honorable Single Judge.
I'm not thinking of that. Fundamental rights means whatever the fundamental rights which is infringed, that's all. And what would be the consequences in the event the court found that it is a violation of the fundamental right, the court have to very, very difficult. That is the only exception on delay and latches.
But then the next argument is whether mere inclusion of name in a select list confers any right
Of appointment.
on him to for
Right of
appointment.
appointment. I agree with you. No. Answer is clear terms no.
And that is also the latest judgment of the Supreme Court on that, my lord. That is Ali Hussain Mandal versus State of West Bengal. They have also taken note of
Again, you are
para 24 to
relying
26.
on the judgment of the neighboring state.
Para 24 to 26. On the same principle, they have taken note of all the judgments of the Supreme Court. So far as this state of Odisha is concerned, that is also taken note of. But apart from all these, my lord, my specific submission, a select list attained finality that was never challenged. Even the writ petitions, successive 2 writ petitions filed before this honorable court, that was never challenged. And there is another judgment of 2026. This is a case after several years, somebody comes forward and says, one candidate has not joined. So I have been posted in X post. I should have been given appointment against Y post, against the non-joining vacancy. That also the Supreme Court says, no right. You cannot invoke after several years. But this is the another judgment of the law. So, looking into the facts of the case,
Let us see.
no, your lordships can, but so far as my submission is concerned, my first question is the writ petition should
No,
not
I
have been
understand.
entertained.
Your major ground is the delay and latches. They slept in a deep slumber for so many years and then woke up suddenly. They cannot do it. Secondly, when there is a reservation of a 10% out of 110 vacancies, 11 vacancies has already been carved out
And
for these home guards. Now, within that 11 vacancies, the horizontal, the reservation, there has been some kind of an introduction.
and once
UR category is lessened, the reserve category has gone more, but that cannot be a ground at this stage to. This is your right.
and moreover, my lord, most important, those reserved category candidates were also never added as party to the writ petition. Now this would amount to unsettle the things which has been settled long back, my lord.
Let us hear it.
In fact, there is no delay. Right? There is no delay. Earlier, I have approved in 2009 before the state administrative law. The lawsuit can find it from page 65 of my.
Then what happened in 2009? Immediately you approached.
Immediately I approved in 2009.
Correct.
2009 matter was kept pending till 2017.
Okay.
After that, this select list was referred. I withdraw that writ petition with the liberty to file a representation before my authority for consideration of my case as they have not followed the home guard reservation.
Yeah.
Then that was not disposed, that even that tribunal are directed to dispose of my representation. No steps are taken for disposal of my representation. Again, I approach my lords. Your lordship are directed to dispose of my representation. They rejected it in 2023. I challenged that in 2023. In the subsequent writ petition, I challenged it. And so far as your lordship have seen that on that, your lordship has seen that counter, my lord, I again brought my lord's notice to the counter filed by the before the honorable single judge.
Yeah.
It is page 8. It is page 80 of my writ petition.
Yes.
The lordship has turned to page 81. 81.
Yeah. Yes.
They have calculated the total vacancy is 110. This was the calculation UR 38, SC 18, ST 24, SCBC 30. Then my next page, the LSMSC, as per the 10%, they have calculated it. Page 82. For UR, they have kept 3 posts reserved for home guards. And for SC 2 posts, for ST 3 posts, for SCBC 3 posts. This was in accordance with the rule and in accordance with the advertisement. Subsequently, my tribunal was that advertisement directed to prepare the select list, taking into account 50% reservation. On the basis of that, the vacancy position of UR, it was raised to 56. Earlier it was 38, then it was raised to 56, and the position of SCBC, it was earlier 30, it was reduced to 30. But so far as Home Guard is concerned, they kept it intact.
Yes.
And they selected only 3 from UR and 3 from SCBC. Though
What is your position in the select list so far as you are concerned?
UR is concerned, my position is 5. So
So
last
if it is
time I have
6,
said, if
then
it will
you
be
come within
6,
the job.
even if it is 5.5, 10% will be 5.6, even it is it will be taken as 5, then I will be taken to the select list.
Yes.
Lordship, may kindly see page 11.
And yeah, Lordship may sit. And the point they have read, the select has no right. I don't have a right. If a person securing less mark than has got appointment, I have not been appointed. And they have kept reserved 3 posts for SCBC. Person securing less mark than me have got appointment, whereas I have been denied. If they would have followed 6 posts for your category, then I would have got appointment as my position was within 5. So last occasion, your Lordship said, if it is taken as 5, then I am coming. And it is not their case, they have not filled up all the posts. If posts are not filled up, then it is discussion lies with the government, they can fill up, they cannot fill up. There, I don't have a right. When they have decided to fill up all the posts, they have to act in accordance with the law, in accordance with the reservation principle. And they have to follow the 50% principle. Here, they have followed the reservation beyond the 50%. If 12 posts are there, 3 posts are kept open for UR, then the reservation is 70%.
Yes.
And this is my case.
Lordship, may kindly see page 21 of the writ petition. Page 21 of the writ petition. Internal page. The prayer.
Yes.
But the prayer I am just placing now. To quash the order dated 39/2023 under Annexure 11. This is the order where his representation was rejected, which is under challenge. The next is very important one. To quash the order dated 12/10/2009 passed by OP number 2. Now, what is that order? Your Lordship may kindly see Annexure 7. Page, I think it is internal page 52 of the writ petition. Annexure 7. Orders passed. My lords have got it.
By DG and IG.
DG and IG of police in pursuance to the order of the tribunal by dated so and so. Now, my lord, accepting the arguments advanced by my lord friend, if he had approached the tribunal in 2009 and pursuant to the order of the tribunal, the authorities took a decision by Annexure 7, and this decision remained unchallenged all throughout the preparation of the select list on several occasions. Now, suddenly, out of deep slumber, my lord, in 2023, he again files a representation. approached this honorable court. This honorable court again directs to consider his representation. That representation was rejected. Now, what prevented him from approaching to this honorable court way back in 2009? It could have been a stage which is much prior to finalization of the select list.
May I explain to that? Earlier in 2008, I have filed an original application that was disposed of with a direction to consider. They have rejected it, and I challenged it in 2009 that your lordship may see page 65.
Yes, but
I challenged that in 2009.
But 2009, when your pursuant to the order of the tribunal, your representation was rejected, you remained silent over it.
That was challenged in 2009. That is a different case for us. My learned friend has not.
Only in 2023 you challenged this 2009 order.
Page 65.
And you have challenged it consciously at page 21. And after finalization of the select list.
Page 65 or 64?
65 when? Yes, sorry, 64 is the page.
There's a case. Yes, that's all. Thank you.
Item 36.
Yes.
Let's see, here something different from
Resolution.
let's start come to the provision of law first, because here is something different from other statutes. Others will have Gram Panchayat Act, and here let's say under the Panchayat Samiti Act. And let's say kindly before let's say coming to the merit to have a very good case, let's say. Let's say kindly come to page 77. There is another point.
Sure.
Let's 100% yes, let's I can convince you, let's say it is a very good case to be. Let's say kindly come to page 77. Sir.
Yes.
Your lordship is well aware of the lordship HON'BLE case and Anil Rai case, lordship. Now lordship recent judgment has come out to Supreme Court, lordship. Lordship kindly see.
HON'BLE has not been taken care of in any of the judgments.
Anil Rai, lordship.
Anil Rai of 2000.
Lordship. Now it is lordship recent judgment.
One SSC or 2 SSC.
Lordship. Now lordship recent judgment is lordship that is Ila Pahan lordship and another.
Ila Pahan case we know.
Recent judgment lordship.
Partiwala.
Lordship, kindly come to page 77. That's why lordship we see lordship something we make lordship we argue in a but in a particular manner, but judgment comes from lordship in different.
Rambali Lordship. Para 16.
Is setting aside of the judge.
Lordship, just I'm bringing Lordship's kind notice because sometimes we argue in one manner, Lordship. Judgment comes out, Lordship, in different manner without taking into consideration our Lordship arguments. That's why I told Lordship, perhaps in the under signature has not taken.
Whether you the written notes of argument.
Yes, Lordship.
Was
No, Lordship.
full submission.
No, without Lordship, it came out no judgment. No, Lordship, no written note of submission.
So how do we know that what you argued and what has not been?
Now, Lordship, I want to advance the Lordship. The pure question of law.
You on that.
Lordship, that now, Lordship, I can argue, I can convince Lordship.
Then I'm reminding you of that A.R. today's judge. State of Maharashtra versus Ramdas, Srinivas Nayak, AIR 1982 Supreme Court.
Lordship, straight I'm coming to the marital case. Lordship, just I brought a Lordship's kind notice because many times it happens. So this guidelines should be there, Lordship.
These guidelines are already there.
Already there now, Lordship. So
Somebody is very clear.
Lordship.
Somebody goes against you.
No, I am just bringing Lordship's kind notice because Lordship, when I will argue on merits, then Lordship, it can, Lordship, I can convince Lordship, these judgments are applicable to my argument. That's why Lordship brought a Lordship's kind notice. Lordship can come to the merits of the case.
That way also, if you take it, this is more on the side of the bail and criminal side. See the kind.
No, Lordship, kindly see the recent judgment. Honorable Apex Court, Lordship, has given
Pilapahan
Lordship.
focused on a bail or the other matters.
Yes.
In other type of a cases, there is one omnibus.
Right, Lordship. So that's why Lordship, I only brought a Lordship kind notice. Now, Lordship, allow me to argue my case, Lordship. Lordship, straight I come to the provision of law first, Lordship. Section 46 here, Lordship, deals with no conflict motion of a chairperson under the Panchayat Samiti Act, Lordship. Panchayat Samiti Act, Lordship.
What the single bench has done, your writ petition dismissed?
Lordship, I'm sorry to say, Lordship, almost all petitions.
You are sorry.
We are traveling, Lordship.
You are sorry to say.
Because Lordship, Lordship, last time, Lordship, kindly, one objection Lordship gave in last writ appeal in a democratic setup. Lordship, I'm not saying about majority. I'm saying about Lordship, the elected members should not be ignored, Lordship. They are throwing out like any means, Lordship. And Lordship, being
I understand. If it is permissible in the statute, then it has to be done in the.
But Lordship, then Lordship kindly come to.
Then you'll have to challenge.
Then Lordship kindly come to the provision of Constitution. Constitution says, Lordship, once elected, they have to complete the entire tenure for 5 years.
No.
Yes, Lordship, can you come to Constitution?
Disqualification is also there.
If here is not disqualification, Lordship.
Disqualification by conduct subsequent.
No, it
is somehow relatable to a removal.
Then Lordship kindly come to the statute. Your Lordship is absolutely correct, Lordship. If it is provided under law, then I will abide by the law.
What is your condition?
Lordship?
What is your ground?
Lordship, kindly come to 46, Lordship.
Yes.
Lordship, 46 says, Lordship, vote of no confidence motion. 46B, Lordship, capital B. May I read, Lordship?
Just 1 minute. Let us these two appear on the page.
Lordship.
Yes.
Lordship, may I read, Lordship? Where at a meeting, the Samiti specially convened in the behalf of resolution is passed supported by a majority of not less than 2/3 of the total number of members having a right to vote, recording want of confidence in the vice chair of such Samiti. The resolution shall be forthwith be published by such authority and in such manner as may be prescribed, and with effect from the date of such publication. On publication, the chairman or vice chairman, as case may be, shall be deemed to be vacant office. Then 2 is important, Lordship, for me. In convening a meeting under subsection 1 and in conduct of business at such meeting, the procedure herein specified shall be followed, namely, A. No such meeting shall be convened except on a requisition signed by at least 1/3 of the members with a right to vote, along with a copy of the resolution proposed to be moved at the meeting. Then B. The requisition shall be addressed to the sub-divisional officer. C. The sub-divisional officer on receipt of such requisition shall fix the date, hour, and place of such meeting and give notice of same to all the members with a right to vote, along with a copy of the requisition and of the proposed resolution, at least 7 clear days before the date so fixed. Then D, Lordship. In the sub-regional officer, or when he is unable to attend any other gazetted officer not below the rank of sub-deputy collector, authorized by him shall preside over conduct proceedings of the meetings. Then E, the voting at such meetings shall be by secret ballot. Then F, Lordship. No such meeting shall stand adjourned to a subsequent date. Then Lordship, and no item of business other than the resolution for recording want of confidence in the chairman or vice chairman shall be taken of the consideration at the meeting. And no such resolution shall be taken of consideration unless it has been proposed by one of the member and has been seconded another member. Then Lordship, for my case, Lordship, the two provisions is very important, Lordship. First, Lordship, it says to C says, Lordship, it has to be convened by meeting will be convened by the sub officer by way of serving notice on the person concerned. Lordship, by way of notice, resolution, requisition, by granting clear 7 days time. In other act 15 days, there are 7 days. Then F is very important, Lordship. No such meeting shall stand adjourned to subsequent date and no item, the other list. So once it is fixed, it cannot be adjourned, and you have to give the clear 7 days time before Lordship convene the meeting, and you have to, Lordship, the larger judgment also says, Lordship, it is mandatory, you have to serve both the copy requisition. Then Lordship, I will come to my case, Lordship. In Lordship, the writ petition copy is there, Lordship, writ petition copy. In writ petition, Lordship, the 2 to 3 dates are very good. Lordship, here, Lordship, annexure 1, page 24, Lordship.
Yes,
Page 24, Lordship.
I can't read.
No, Lordship, only I am giving the, only give the date. Dates only, Lordship. I will not the contents, Lordship. Only I go by the dates, Lordship. Lordship, on
11/7/25.
11/7/25, this sub-regional officer issues notice to the all concerned, Lordship, by way of fixing the meeting will be held on 19/7. Lordship, this is the contents of the entire letter, Lordship.
So 8 days, clear 8 days.
Lordship, I come to that, Lordship. And they admit, Lordship, that they admit, Lordship, they admit on their counter, the notice has been dispatched on 12th and it is reached to the person concerned on 16th. So, Lordship, there is no clear 7 days time. So that's why, Lordship, what he did, Lordship, the person, Lordship, the sub-regional officer, Lordship, can you come to page 29? Immediately after getting the notice, because the notice was without resolution requisition, only notice was served by the petitioner. Immediately the petitioner approached with the authority, please supply me both the resolution requisition copy. That is on, Lordship, that is on 17/7/2025. Because the petitioner received on 16, on 17, Lordship,
In this letter, it has been annexed.
no, Lordship, that is not done.
Talking of, there should be some.
No, Lordship, that is not there. That is not, they have admitted, the Lordship, they have admitted in their counters. Controls, Lordship. Then, Lordship, kindly come to statement page 33. While this was the situation, Lordship, because there is no clear 7 days time,
Mr. Dala,
Lordship.
ଏହି ନୋଟିସ ସହିତ ଗୁଡାରୀ ପଞ୍ଚାୟତ ସମିତିର ଅଧ୍ୟକ୍ଷଙ୍କ ବିରୁଦ୍ଧରେ ଦଖଲ ବରାଦ ଚିଠି ରିକ୍ୱିଜିସନ
Lordship.
ସହିତ ସଂକଳ୍ପ ପତ୍ର ରିଜଲ୍ୟୁସନ
Lordship.
ନକଲ ସଂଲଗ୍ନ କରାଯାଇ
Lordship, that what they have
given.
what no, Lordship, they have not given. But they have given. Lordship,
That is your case, but
no,
the
that is not my case.
document
That is their case. Lordship. That's not my case.
No, that is your case because
Yes, but because they have filed counter, I will demonstrate the counter part also, Lordship. Where their admission is there, also I will fully demonstrate that part only. Lordship, kindly state page 33. In the meantime, what the deed, Lordship, kindly come.
show us.
Yes, I come to.
If that is there, this notice says that the copy of the resolution and the requisition has been annexed. Sanlagna means enclosed.
Look,
What more?
I'm strengthening my argument by demonstrating another record, then I'll come to that. Lordship, kindly come to page
You have to
33.
go by the record.
Lordship, kindly come to page 33. Pardon, Lord. Lordship, kindly, Lordship.
Where is their case that they have not sent it?
They have not, Lordship, page 33
Show
says,
us.
Lordship, kindly see page 33. They have cancelled the meeting. They have adjourned the meeting.
Oh, that is a different point.
This is not that.
That is important.
That is the F. You are talking.
Yes, yes. Lordship.
So not C.
No,
It is
no,
F.
no. I
So let us start C. That you have no case on C.
yes, I have a case on C.
So
Lordship.
show us
Lord-
one by one. First demonstrate C.
Lordship, kindly come to the counter.
Correct.
Counter.
We find 7 days.
Lordship, kindly come to page counter.
Find requisition.
Lordship, para 6.
In this with a separate endorsement.
Para 6. So that is para 6.
Of
The counter.
show
Page 3.
paragraph 3.
3 Lordship.
Yes.
Para 6, page 3 Lordship.
The paragraph 6.
Para 6.
Okay.
Lordship, got it Lordship?
Yes.
That when it came to the notice of the sub-collector Gunpur, that the notice dated 11/7/25 could not be posted on the same date. Lordship is admitted now, we have not posted.
Whatever.
Lordship.
Read.
But it was posted on the very next day, that is on 12/7/25, in order to extend the minimum period of 7 days notice. Yet, to all the members as required under law, the supplemental Gunpur again received a special meeting on 24/7/25 by the letter notice dated 15/7/25. The said notice. So, Lordship, their admission, because it is defective one, so Lordship, again they have come up with
So what
another.
it says that they have not annexed.
Lordship.
That you were talking about that the notice which was given
Lordship,
did not contain the requisition or
yes,
the provision
Lordship, because
that shows that it contained.
Lordship,
Now they say that since it got dispatched on 12,
Lordship,
7 days notice could have been short. So thereafter they postponed.
Lordship, I have to comment Lordship in this manner, Lordship, because it requires Lordship the experience of ground reality, Lordship. Lordship, can see here is not case of posting, Lordship. Here, Lordship, the every member has to serve with the notice and request register.
This is not a new
They have not,
phenomenon.
they have not done it, Lordship.
This is not a new phenomenon of this state. Ground reality in other state is also the same. Don't worry.
No, something, Lordship, because the rules may be there.
No, it is the same thing.
Same,
Yes.
then we all are suffering, Lordship.
Yes,
It's a disconduct of the Lordship. All are suffering, Lordship.
It is also under the Panchayat Act, the limit of the union Pradhan.
Lordship.
Everything is provided.
So it has to be served on paper, Lordship. Our signatures, they takes our signature, Lordship.
Sir,
With
there are two
endorsement.
modes.
That
There
I-
are two modes. Somewhere they send it by certificate of posting.
No, that is in the Gram Panchayat Act.
I'm saying
Lordship.
there are, in certain cases, they are sent it by certificate of posting. There is another, they send it by registered post. There is another, they send it by repeat post. And there is also a provision that the Panchayat office officer, he goes home to home because.
Grateful, Lordship. Grateful, Lordship.
Panchayat and serve it.
Grateful.
And take a signature of the.
Grateful, Lordship.
Sir.
So, Lordship, there is distinction between Gram Panchayat and this Panchayat Samiti Act. Gram Panchayat, Lordship, section 24. C says, Lordship, it has been noticed
Nothing-
along with
nothing is
distribution.
there anyhow.
And he says, Lordship, through post. But here there is no question of post, Lordship. Here, Lordship says, service of notice is mandatory. So it has to be served on the person concerned by the authorities. They have not done it. So, Lordship, they have not, never, Lordship, they have supplied their source copy.
Sir, there are two aspects.
Lordship.
One is there is no provision that after receiving that particular requisition
Lordship.
and the resolution
Lordship.
having passed by a majority,
Lordship.
the sub-divisional officer has to issue a notice within a time frame.
Grateful, Lordship.
It is not. It is all, say, immediately, promptly.
Lordship.
But only thing is that once he issues a notice fixing a date, time and a place,
Lordship. Lordship.
then he should adhere at least 7 days
Great.
difference.
Grateful, Lordship. Lordship.
That's the only thing.
Lordship.
Suppose if he issued a further notice that shows that impliedly he has withdrawn or cancelled the earlier notice.
Grateful, Lordship.
If he, and then again if he fix the time, clear 7 days, where is the wrong? I'm just.
Lordship, just I'm borrowing your Lordship statement was given last in another proceeding, Lordship. We all the citizens who are abided by law and we can't do anything which is not available under law.
Correct.
But the statutory authority cannot do anything which is not provided under the statute.
Correct.
Lordship, where is that, Lordship?
That's the
Where is the
fundamental
statute?
administrative law.
No, the statute never provides, Lordship. Rather, there is a bar. Lordship, can you
No, I'm-
2x?
No, Mr. Loy,
Lordship.
let us understand the thing.
Lordship.
Suppose a one third members of the submitting,
Lordship,
they made a requisition
Lordship,
to the sub-divisional officer
Lordship,
with a copy of a resolution
Lordship.
that we have shown our decision that we have no confidence in the
Yes.
chairman. Right?
Lordship,
He has given on that.
Lordship.
Now, the sub-divisional officer say sat over for 15 days or a 1 month
1 month, Lordship,
and then issued a notice.
Lordship.
Will that notice be invalidated automatically because sub-divisional officer?
No, Lordship, that is not my case. Lordship,
I'm putting you
That's number one.
I'm putting you different hypothetical
Let's-
situations.
Lordship,
So it cannot.
Lordship,
So it all depends upon the wisdom of the sub-divisional officer.
Lordship.
Correct? Second situation. After receiving the resolution, he immediately issued a notice giving a particular time which fell short of 7 days.
Grateful, Lordship.
He noticed that it fell short of 7 days, not in conformity with the law. Is he debarred from withdrawing such notice or cancelling such notice?
That shall be before Lordship. If Lordship
Now,
justify their action, then we don't have any case.
Debarred.
Lordship, if Lordship
Any
justify
law-
that action, then
Secondly-
we come up with Lordship
Secondly,
in reverse manner.
if suppose
Lordship.
the notice falls short,
Yes, Lordship.
will the resolution of 1/3 automatically
Yes,
persist?
that is the law, Lordship. That is the law. If Lordship by this Lordship will settle the law, that power with the authority, then we don't have any case, Lordship. We'll go by that, Lordship. So that's why we're before Lordship.
According to you, notice has to be issued once. only.
Yes,
So if there is no clear cut 7 days,
Lordship.
immediately the authority comes to know about it.
Lordship.
He has no scope to
No.
rectify.
statute never provides for.
Oh, what has happened has
Yes, Lordship. That is statute provides for, Lordship. Statute, Lordship, that's why, Lordship, I'm borrowing Honorable Chief Justice, Lordship, one of the observation. The statute cannot do anything which is not provided in the statute.
there. What-
He's not using, Lordship.
That is the law, it's not my observation.
Lordship.
It's the two
So
fundamental.
he can, that must be, Lordship, within the four corner of the law, statute.
I am
That
asking
power
you-
must be with the
I'm-
statute.
I'm simply asking you, sir, that there is a mandate which is given that he cannot withdraw the notice.
That's why, Lordship, 2F, Lordship. 2F,
Incidental matter.
2F, Lordship, can you see?
2F says that once he has fixed the
Yes.
date,
Lordship,
then he cannot adjourn the hearing.
he has already
If
fixed,
it has
Lordship.
commenced,
So
if
19.
it has commenced, he cannot.
Already, Lordship, already fixed to 19th. And 19th, Lordship, I have, in the meantime, I have already approached this on court. Challenge the same, because you don't have that power. You can't extend, Lordship. That is the law, Lordship says. If the law will say, otherwise, Lordship, we are sorry, Lordship, that can be. So later, Lordship. Lordship will go by that definite, Lordship, that will be law of land. But my understanding, our understanding, Lordship, when the statute says, Lordship, you can't adjourn. A defective notice cannot be rectified by himself. That's why there is a provision, Lordship. If the time, once it is, Lordship, deferred or Lordship failed, it cannot be moved for 1 year, Lordship. That relaxation with the Lordship, public elected representatives. If I read the entire Lordship, the provision of 56,
I'm
36,
seeking your
Lordship.
submission.
Lordship.
Yes.
So, Lordship, here, Lordship, their own admission we have ensured because of there is lack of, we have not qualifying, we are not satisfying the 7 days qualification as statutes provide. Lordship, one para 8 lordship can receive more damaging by the counter lordship para 8. Para 8 lordship.
Wonder upon the thing.
Lordship.
We are fixing this matter for this. You'll have to come and argue on merit.
Malik, sir, just I wanted to bring one point to your lordship's notice minutes. The no confidence motion was held, the votes were counted, and the notification was also published. I was removing the
If
for lordship's
the
information.
information goes, then the castle which is built thereupon has to fall. He is really pointing on a foundation. The foundation which led this edifice to come, if it is a faulty one, then how the structure can stand?
Well, let's post it another day.
Come with the line of judgments where it says that if an authority has a power to to do a particular thing, then the power to correct the mistake or the power to recall is inherent and ingrained into that line of judgments you should bring. Duloi also come with that line of judgment.
That's for that. I have elected
When both of you, when you can, if yourself ready.
Well, it's next week except Monday. I'm not here on Monday, any date after Monday.
Monday is the date for those matters.
Third it will be next month.
Come on, third. It will be.
Yes.
3rd August.
Yes.
Item 37.
Yes.
So yeah, I'll look for it on Monday. Yeah,
Yes.
Very carefully I will hide by the opposite.
Who is representing the Orissa Lift Irrigation Corporation?
My lord, yet notice has not been issued. That notice we issued, you are lucky that because Mr. SP 40, who usually
You are
answers
representing
a private
notice.
next week.
2 weeks. Private or private?
Private.
2 weeks.
My friend appears for private service.
Orissa Lift. Orissa.
Item 38.
You're lucky. Oh, right. Oh, right. You're right.
In this case, the matter is similar to item number 1.
39.
Matter 38 is similar to item number 1. And this case is hard at length. Hard at length. And earlier it has been tagged with that item number 1. Subsequently, the last occasion on the request of the respondent, private respondent, it has been said. But the impugned order is passed basing on the common judgment. That common judgment and my promotion order has been passed.
And the what, item number 1 is given.
Tomorrow.
Next month.
So should be listed in the next Monday, not together as standard matter.
Okay, so if the appeal is not done.
Okay, sir. Okay.
39.
Yes, the last members, there is a maintainability is the question now. The order that was challenging the writ petition arose out of a judgment passed by a district judge. That arose from a
For 226 lines.
on the last petition, my knowledge of India had proposed that.
But about 226 lines.
I beg pardon.
Out 226 lines.
227 petition.
No difficulty. Whether the learned judge has a roster of 227?
Yes, ma'am.
Where is that?
My lord, your lordship may kindly have a glance. To the
That is
On the other day-
is not printed in the book.
the roster,
But in 227, there is no provision for a further appeal.
On the last petition, lordship had checked the roster.
no, on the other day,
Show, let him show. I do not
the judgment was pronounced on 10/3/2026.
Please show us that on that day he had a determination.
On 3/12/2025, it was the register of the judge.
I am asking you that.
I had an application.
Whether the hearing was concluded prior to that, I'm just asking.
Hearing was concluded on 3/12/2025.
3/12/2025. Whether on that day he had a determination?
Yes, ma'am.
Sure. Show us 3/12/2025.
I asked in the registry, they could not supply the copy. They told that it is only available in NIC and in the concerned court. Otherwise, it is not available.
3/12/2025. The judgment was that.
3/12/2025.
Argument was reserved.
Yes.
Completed on that day. 3/12. So that should be the date.
Yes.
What's up? Because judgment has to be delivered within 3 days. 3 months. Which one? This one. Show me that which one is there. Please. Sure. Where is the power of reflection?
Number 2.
Elections, that is a different organization.
Read petition relating to municipal act.
I am asking you 227, does it come?
All these
All 227 applications are registered as what?
registered as WPC. Not the CMP, it is WPC. Let me take your lordship to the High Court of Orissa.
It is WPC. It is registered as WPC. But the rule XV of research in the chapter 15. High Court rules. And the very same point was raised before a honorable division bench, whether the judgment passed by the Workup Tribunal, a writ petition like, it will be numbered as, it is a writ petition under 227, whether it will be numbered as a WPC or a CMP. The honorable division bench hold that it has to be registered as the WPC. And I have obtained
I'm asking you, which one you are referring?
chapter 15, rule 1,
Yes, sub-rule, clause. which
clause
one?
A,
Roman.
chapter 15,
A, you want.
one small.
An application
An
for
application
direction
for
of the
direction of
betterment prohibition and any other direction
Any other direction
or
or
an
order
application
under
that be addressed in the company and judges and placed before
the division bench of the honorable judge.
may be directed. So this
Clause
common thing.
Of the same rules come to rule 5. That clearly.
Let us see
Yes.
A, how it is relevant.
Oh,
Or it is
division
relevant.
bench or single judge. No, not same mark. Or single judge.
Sir, it has to be addressed to the Chief Justice.
My lord. And will be placed before such division bench or single judge.
As the Chief
As the
Justice
Chief Justice may direct.
direct by general or special order. I
Yes, Lord.
asking. It's a different, it's a categorization roster.
Yes.
Then what
Your
about?
lordship B.
Huh?
And B, there is categorization which will go to the division bench.
Correct.
And below the B, after the proviso, all other matter will be listed before the honorable single judge.
So, no doubt, who disputes,
And this matter,
but only thing is categorization.
categorization.
Whether it is 227 or 226.
It is 227.
Correct. Whether the roster was given out the 227.
That is clause 2.
Then, sir, if I accept your contention, then all matters,
My lord.
irrespective of its category, will be distributed amongst the single bench. Any single bench will take up any matter not assigned to him, he will do it. Because all those matters which are not coming under B will go to the single bench, and single bench, any judge of the single bench will take up any matter. There is no
No, your
difficulty.
lordship,
And
your
when the
lordship
Chief
in
Justice is merely
in this assignment,
spectator, no master of rosters. No master of
your
rosters.
lordship may confer a report from the registry.
No.
They are not cooperating. They are not furnishing the reply
It
to
is
me.
CFP always, because I have been taking CFP. there.
For a
Your
moment,
lordship, every day read of it, here is the writ petition, WPC.
for a moment, my lord, it
And
is
the-
rule 5 of the same
Rule-
chapter, my lord. High Court.
Rule 5 provides
Every
that only-
application shall be registered as read petition civil WPC except an application for habeas corpus registered WPC. Applications under Article 227 of the Constitution arising out of a suit or a first of
CFP.
Yes.
shall be registered same.
So,
only suit and a first of it. This is neither a suit nor a first of it, because it is a
First of
tribunal's order.
it.
Election tribunal's order.
what do you mean by tribunal?
The election tribunal, under the Gram Panchayat Act,
Sir, that's why I asked you a very simple question.
my lord,
That if a district judge is entertaining a petition,
right?
is he entertaining it as a persona designata, or he has a trapping of a court?
My answer is, it is a trapping of the court. There is series of
I
judgments,
am asking you, if it is a trapping of a court,
right?
then in that event, well, 26 lies, no.
Only 227 lies.
Now,
Even if-
question is not 227.
My,
Then 227, if it lies, then will it not be registered as CMP?
it has been registered in the Odisha High Court as WPC.
But that is wrong one, because the 227, if it is there, I have been taking a very exception to it.
My lord,
Whenever the petition is given, an application under Article 226 and 227 of the Constitution. I said you'll have to say either 226 or 227.
Right, my lord. In series of the judgments up to this Honorable Supreme Court, merely because someone has written 226 or 227, it has to be construed as 227. It has to
No,
be
it has to be converted. There is no fetter, or there is no bar that an application which is captured as 226 can be converted into 227.
Well,
Can be done. But then it has to go to a respective judge having a roster of 227.
my lord, here is the rule provide after presentation of the same, the matter will be placed before the stamp register. The stamp
Show us
register.
the division bench judgment as you say of this court. Show
Well.
us. Let us see what it says. Section 89 of the Walker Act.
Yes. Taken note of chapter 15, clause A, B. Every application shall be registered as read petition civil WBC except application habeas corpus WBC, so and so, application under Article 227 of the Constitution arising out of a suit or first appeal shall be registered as a civil miscellaneous petition. And this is arising out of a order passed in the Waqf board, Waqf tribunal. Thus we are of the paragraph 5, last line. Thus we are of the considered opinion that the present petition has been rightly placed before the roster division bench. Further, in view of the ratio of Kiran Devi, observation of a coordinate bench in this case in Aurangzeb Khan and Kansho is no more good law. We therefore hold that the writ petition is maintainable before the roster of division bench.
I would in instant case, the order that was challenged arose out of the first appeal.
the let's wanted the third requirement is assignment is election appeal and election dispute concerning local body, that is municipality, NAC and GP. That is also the assignment of that code. This is arising out of Gram Panchayat dispute, which was first filed before the Land Civil Judge Junior Division and thereafter in appeal to the Land District Court, District Judge, and a series of judgment right from 1961 Supreme Court in Central Talkies case, followed by Thakur Das in 78, 1995 5 SCC Mukuri Gopalan, 2003 SCC Online Calcutta 219 Pasupati Adhikari.
Pashupati Adhikari is a different case. That is on the question of court, tapping of a court and persona designator. Under section 8 of the Land Reforms Act.
2015 5 SCC page 423 Radhesham and Chavinath.
Chavinath is a different than Radhesham, and Chavinath was considering the earlier case of Suryadev Rai.
Also hold that in certain paragraph it is a district judge is a court. It is not a persona designator.
I'm saying the question is 227 or 226. You say 227.
227.
If it is 227, then in that event he must have a roster to entertain 227.
Minor.
You say that it is a writ petition registered in that way. So it is a roster within him, is a roster of the same judge.
Minor.
And he enjoys the 227 power. Though the 227 has to be registered as CMP, but there is no difficulty in registering it as a writ petition. Your contention is it is registered as writ petition.
Yes.
Well,
Correct? Chapter 15, Rule 5 has to be ignored to that extent or to be interpreted in that way.
Chapter 15 provides that
First appeal or a suit.
Suit.
Now that is what I am saying.
Other than those, the entire filing of the before this honorable court.
Now,
this
suppose when an approach is made to the civil judge scenarios.
Right.
With what? Election petition.
Election petition. Right.
Is registered as
Election discuss.
appeal is provided to the district judge.
Right.
Registered as
First appeal against orders.
the first appeal.
First appeal against orders. It is not a regular.
Whether 96 of the CPC or order 43 is a different issue. I will come, but it is a first appeal.
First appeal against orders. Because this is the only.
So he enjoys an appellate court.
Appellate court.
Correct.
Right.
This is now the second forum before the High Court. Whether the writ would lie, 227 would lie, and if it lies, what is to be the correct categorization which should be given? WP or it should be CMP when both exist together. When both exist together.
As per the High Court rules and as per the practice, it is registered as WPC.
So according to you, there is no dispute. I will take it that it is a trapping of a court, and thereafter the High Court can entertain. There is no difficulty. 227 is the mode. WP is the appropriate categorization. Right, take it. Let me decide that on that score. Give me no list of Chavinath. There is no difficulty. There is Radhesham, Chavinath, Pasupati Adhikari. I think there is no quarrel to the proposition.
Should I give in writing? It is 910.
Okay. Give me that roster.
Yes, ma'am.
Along with the make a plan.
Is Jairus को ढूंढना है सर Jairus को ढूंढना वो सी Jairus को ढूंढना
Make call the next one.
Yes.
Item 40.
I just want to quickly review matter regarding Concern of the Gram Panchayat executive officer. That's initiated against the Gram Panchayat executive officer. And the learned similar relying upon his earlier judgment has decided that collector is the appropriate authority for initiative security. Collector is the appropriate authority to initiative protection. That is now under challenge before lordship, saying that collector is not the authority, although that has been decided earlier, that earlier judgment has never been challenged. And now the second interpretation now says on the challenge for us. And the second, the present interpretation was disposed of state of admission relying upon the earlier judgment. So no counter affidavit was filed like that in the present interpretation. We have to file a counter. Counter is now available. Give some time, we'll file a counter.
No. Whether you find your counter in the
Earlier. No.
Before the single bench, you find the counter.
No. At the stage of admission, matter has been decided, saying that in view of the earlier judgment.
Well, my entire case lordship on judicial discipline lordship. Full bench lordship, full bench of this honorable court, division bench lordship, and other court benches have passed order in a particular line lordship. They are saying the collector has no authority because while I am working under the Gram Panchayat, I am not holding civil. No, honorable civil judge, ignoring all those judgments lordship, he relied upon his own judgment, and despite making submission that the larger bench judgments there, full court judgment is there, divisional judgment there, and other court benches for the same order, is not relied upon any order. That's why lordship is given interim order.
That order has not been challenged by you. You are the counsel for that case. We have not challenged that case.
That is just under challenge.
Now in the second case, we are challenging.
It does not mean when a division bench is insisting of a particular matter, even if the earlier judgment of the single bench is operating in the field, whether there somebody else.
So on that I am not arguing. I say
the
it was
division
within
bench
his
should
knowledge.
decide the matter.
That I am not arguing on that. But I say it was within his knowledge that earlier.
No, I understand you wanted a time to prepare yourself. Say that.
Yes.
How much time you want to get yourself prepared? 1 week. Put it in the next week.
Yes. Interim order.
Yeah.
Both the cases.
41.
That's interim.
Yes.
Sorry.
As the honorable saying,
And
order में page annexure 8, page 37.
37 or 39?
Yes, sir.
Huh?
39 starts from 39. Batch of applications are disposed of, including mine matter 14842, which was in the middle matter. And the relevant portion matter page 40, 51 and 6. Though all those applications matter were covered by 3 years cap, whereas my case is different.
Keeping it for 3 years.
Yes.
Living function.
After one and a half, 8 months.
Yes, is it so?
He has completed, so far the cluster is concerned, he has completed for more than 6 years, 9 months. And cluster clarification, he will also have a class instruction.
What is this new document you are, did you place that matter before the single bench?
Was it there?
No. Did you place those documents there?
But they are also, we have submitted his continuing more than 6 years, 9 months. Cluster, he also can have a cluster only page.
Sir, can you count to page 50? The document I have prepared, but I have filed. Based on that, now the honorable single judge accepted that. Because a batch application is disposed of, if you are not
The thing is
This is the instruction. This is the
This is the instruction, then you bring it on affidavit. Affidavit by 1 week.
Yes.
Rejoinder within 3 days. Matter after fortnight.
You still protection.
Nobody. Nothing. In transfer matters, no interception.
No, before that, I was continuing.
No.
Item 42.
Item number 42, my lord.
The flag, if you can see flag B, another colleague of mine.
42. Item number 42, I am appearing for respondent number 5.
Who is appearing for the appellant? Mr. Joyce K. Krishnan.
Only thing, madam, I will say two sentences. If your lordship will permit. Only two sentences. Issue involved in the writ is as together in a consolidation proceeding. The title have already been declared in favor of the opposite party number 5. Thereafter, any proceeding under the Service Settlement Act is maintained.
Is one sentence. What is second?
That was the finding of the Lawrence single judge that once
Madam, but other side is not.
they will not
Can
come.
I enter into can we
And
enter into the merit?
no,
We have to dismiss it for default, nothing more than that. Supreme Court has given a many judgments. You cannot decide the matter on merit
In absence
of. So we have to dismiss it for default, nothing more than. Was it mentioned by you or other side?
by me, my lord.
Did you give a notice to them?
Mention memo, I have filed the mention memo.
No.
Along with my petition for early hearing of the case. That was served.
No. Did you serve them?
The interim application which I have filed,
From Mr. S.R. Acharya appear.
I have solved the copy, my lord.
S.R. Acharya.
Yes, Mr. S.K. Boral, I have given the copy.
Dismiss. What to do?
Dismiss for report.
Before. As prayed for. Yes, is the court of the record and appearance. Dismiss.
From 43.
Donation service. Affected.
My learned friend has.
Have you got the copy of the?
Yes, sir.
How many days delay?
280.
They say it is 218 days. After we
What is
filed
the
it,
ground
Round will para 4.
of the
IA application. That is a flag A. Flag A.
amen.
IA 157 of 2026. Para 4. The only ground.
Paragraph 5.
Para 4.
Paragraph 4. After your lordship issues notice on contempt, they only file.
Where is our judgment?
That I.
Last judgment.
Yes, your lordship have been pleased to pass a judgment. They say in the Supreme Court judgment that is there with me. But I am taking apology because I have not brought your lordship's order.
There is a judgment of Justice Pankaj Mittal. There is a judgment of subsequently
Yes.
Justice Patiwala. Where are
6
those
judgments,
recent
your lordship have been pleased to refer in that recent judgment.
That is what I am
I've got
saying.
only
Where is
one
our
judgment.
The same petition.
Here if the lordship will find.
What is the matter about?
After about, we have been allowed by the learned honorable single judge to be reinstated in our services. Those we have been, they have terminated since 2012. They segregated 2 sets of employees. They told certain employees to be deputed and allotted them and reallocated them. And we are left on the white. Honorable single judge decided that we should have been also treated at par with them. And we should have been taken into consideration.
They were working since?
This is, they say, closure of a particular organization of
Project.
SIET.
Project.
Yes. It's an organization for imparting educational systems to the schools and colleges. They say it is State Institute of Educational Training. Yes. They say it is closed. Now, some staffs we had
By close
recruited.
of time it goes.
Yes.
Persons, those who were regularized, they were working as against the sanctioned vacant post.
And subsequently on closure, they were accommodated.
What judgment you are citing?
No, my lord, that's the
in
judgment.
relation to something else.
Yes, ma'am. That is, I just mistook it, my lord. That is on delay.
No, it is not on delay.
That is after filing contempt
So
application.
that is what it says, that it has become a regular routine that the once the contempt application is filed, the appeals are coming out with the section 5.
Yes.
But what the court should decide at the time of section 5 is not a judgment.
No, that is not.
Then we are deciding section 5.
Well, that your lordship may give me 1 day time, I will place it.
What? Yes.
I know that.
Our view. You know our view.
To change of work, there was reassignment. That's para 4, if you mercy,
It's a very vague sentences which has come when it has this situation there is when it has been done. How the judgment was passed on 25 for 9/6 you decided when it was forwarded. When the order was forwarded by the government advocate. What decision they take, where the file moved.
in the Advocate General Office, it was received on 22/8/2025.
Huh?
22/8/2025.
Correct. So why there was so much delay?
Then it was assigned to the additional government advocate on 3/9/25. Thereafter, the appeal has been prepared and filed on 29/12/2025.
No, it was not filed. It was filed in
29/12/25.
No. Your number has come in 57 of 26 earlier.
Again.
25.
With your lordship's leave, I am assisted by one of my associate friends. The lordship delivered by your his company.
Allotted by the registry of this honorable court on 12/1/26.
Can't be. We are bound by our own judgment. In your case, you argue. No, the party.
Mr. Tripathi. One case, Mr. Tripathi, and one case.
This can't be done. No.
But if the lordship will look at the merit of the case, then
What is the merit?
merit, my lord, 2 sets of employees on closure of the institution, they were accommodated in another institution. I have not gone through in detail the merits, but I am just making a sufficient. The teachers who were initially accommodated, they were continuing against a sanctioned vacant post, 63 number of posts. So they were absorbed. But so far as the petitioner are concerned, although they were continuing prior to the cutoff date, but they were continuing against the, I mean, the contractual posts. So that is why they were not subsequently on closure of the project, they were not.
No, the other employees, the other teachers who
Yes.
were there in that institution which got closed or which was closed subsequently.
Yes,
What was their status there?
they were regular employees, continuing against sanction bracket
And they were continuing against the contractual.
contract. That is the reason because. And the cut-off date, they have the honorable.
And what was the decision taken while transferring them to another institution and absorbing them there? Does it contemplate the contractual appointees as well?
But that, I'll have to come back and say because on merits.
Because that notification is very important by virtue thereof.
Yes, we have enclosed, we have filed the counter affidavit, everything has been. I'll make submission on that.
When you talk about the meritorious matter, I understand, but that we have to consider that. So if we do not find, then why unnecessarily regret?
So Lordship, then we will do next week. We can come
We are
prepare and.
actually tomorrow come ready and tell us.
But
Keep this matter is tomorrow and take a print of this, give it to the housing. Just take a print.
Yes, please.
Let's go to the next.
Item 44.
Good afternoon. So very instance of the disciplinary proceeding has been filed by honorable single before charge sheet was demanded challenged in the writ petition.
On what ground?
On ground limitation ground. Yes, ma'am. So
Before I
am appealing for the response. A copy of the writ appeal may be sought. You are
for opposite party.
Yes, ma'am.
Private appeal.
Single appeal.
Single.
Okay. Multi-party.
There is only one opposite party.
One man.
You are representing.
Yes, ma'am.
With whom? Who will find the Mogaladama?
I have filed. I'll solve one.
Such affairs and submits.
Forty-five.
Behalf of?
May I submit one thing? This matter has become infructuous. This heat up.
There's some emergency here, rush to the hour next week.
Item 46. Item 47.
My lords, there's a condemnation of delay application. The delay.
Notice has gone.
No, notice has not gone. My letter friend appears for the respondent. If you are
Respondent?
Yes,
Pay
ma'am.
the service.
Yes, my lord, I have filed all the documents.
You've been served with a copy of
Yes, my
presentation.
lord, while in the sanction petition, they saw.
How much is it?
My lord,
97 days.
97.
97 days.
Yes, what is the ground?
There is no explanation. my lord.
No explanation.
Only administrative lacuna, my lord. And that is hit by your lordship's judgment. Only para 3.
Petition is this, sir. I have not come across in my career over there and here. Both. Is section 5 application of such nature, I have never come. This is an application for continuation of debate.
Soft copy to repetition petition particular not. I saw it in course of the journey.
Copy of the petition.
Repetition.
Yes, liberty. Next.
Item 49.
One delay manner. It is issued manner.
Notice to be issued.
This is issued manner. And
Who is appearing for the other side? Service affected.
manner.
So undelivered notice, respondent number 5 and 8.
Last noting will also cancel. Last noting will not council acknowledgement.
What?
Last noting.
4 to 9 appeared.
9.
Who is appearing?
Mr. Das.
Anand Prakash Das.
Where is he? Mr. Anand Prakash Das? Where is he? How many days delay?
7 days. No one.
Despite service, despite the appearance made on behalf of the
The repudiates have been denied.
no liquidates incomplete, sir.
I have been just kindly see.
Today,
No, wrong, but within this time, at least stipulated time period,
liquidate for respondent number 1 not 5.
that I have given to deputy here. That
No, we are appearing for the, but the Lordship may issue notice because the competent authority of the appellate authority under the PG Act is a different capacity. Better to Lordship may issue notice.
the deputy.
I have received the copy already sent to them.
I have given.
Incomplete. File it in the department.
No, I am showing the event. I have filed already. Within the stipulated time, I have
But the report says that you have not put in the requisite for responding number 1.
Yes.
I have submitted this copy of this requisites.
From DSJ.
Before the office of the deputy solicitor.
No, but says that kind of right, but this is an authority which has an independent existence. So that's why the requisites have to be filed.
Well, let's say only the tomorrow.
Time to put in requisite is extended by 1 week from the.
Item 51.
Put up the matter after the service is effective.
Notice has been issued to the opposite party. I have also served
The condition has been served or not?
Yes, ma'am. I have to serve extra copy to the bank minors to the OP number 3, 4, and 5.
I am appearing for the OP 3 and 5.
And private opposite party is OP number 8.
I have already appeared on behalf of opposite party number 8.
No, it is says that 2 and 7 returned.
2 and 7. I will serve extra copy to the state.
I will take for 2 and 7.
Oh, you take it. Yeah, return with the insufficient address.
I can take more. I can take
Update. Go ahead. 2 and
7.
Who is the assistant registrar? 7 deputy registrar.
26 days.
26 days we delay your lawsuit. File an objection because no sufficient ground they have explaining lawsuit.
Where is the finish?
How to call a small object in plugin?
Paragraph
A.
Paragraph.
Paragraph 4 is the only now.
Yes, madam.
No, what is this?
Not to me, allow me to explain, I may explain.
Without breaking you let them know. Better from. We can grant to file an additional letter. Within a week from, well.
From 52.
Survey says the effective.
Survival matters, we will check for 27 days.
Both.
Item,
Notice.
item 53.
Delay.
May put your option. When there has been a delay of 254 days in preparing this document.
By the way, object, sir.
You have filed your objection.
Yes, there is no, absolutely no ground made up
Mercy.
in the petition.
That I-
Lordship, may kindly have a glance.
All right,
Paragraph four.
Lordship, may
Paragraph
kindly,
4 is the.
all right, your Lordship, may kindly see a date.
Flag.
Paragraph 4.
A.
Lordship, may kindly see this date chart. I will not take much time. Small date chart, Mira. The dispute is very limited, Mira. Lordship, may kindly see.
We are on section 5, sir.
Yes.
We are only on section 5 application.
Yes, please. Plus, notification was issued.
Where you have stated in the petition. In the section 5 petition.
Yes,
Where
ma'am.
you have stated, sir.
Section 5.
Please.
Section 5. Yes, sir, Lordship, may kindly see section 5, please.
Please.
Yes, the book. WPC number 149 of 2004 was disposed of on 21/7/2005 and I have preferred the present review application.
Correct.
With the delay has occurred, I have prepared a small date chart. Will you place it?
No, on the petition, what is the date chart? You cannot argue something which is not there in the pleading.
Yes, but it is everything is ready.
Please concentrate on section 5 application, what you have stated.
Paragraph 4, you have to find.
Please read that.
Paragraph 4.
It's a handwritten after the
That some
is
delay occurred due to intra-departmental correspondence and pending review application. So that was the delay. The review application was pending before your office. For that is in delay.
What was the period of the pendency of the review? 10/3. When you filed an appeal?
8/4/2026. Yes, I would have checked.
What did charge?
Merit on the merit, second. Actually, the land vested in 1988 with MCA.
We are in section 5, sir.
Yes.
You know the distinction. We will enter into the merit provided we condone the delay.
Yes, I don't dispute that. Yes.
So, we can't enter into the merit.
Yes, ma'am.
If it is dismissed at the threshold, then everything goes. Yes, what you say?
Absolutely no explanation given. Even they filed a review petition after 76 days of delay. That review petition has been rejected.
That's on the ground of delay or merit?
Delay.
On the ground, no, on merit. On merit.
Review on merit or delay ground?
On delay ground, it has to be rejected.
No.
Review.
Review has been
merit, no?
dismissed on merit.
Dismissed
on merit.
Merit. But my
Within 1 month from the date of the rejection of the review application.
This is not an application under section 14. This is an application filed under section 5. They could have filed an application.
There is a provision for an application under section 14, sir.
Well, 5.
Well, if they are pursuing a remedy, if they will take advantage of
There is a
that.
provision for an application. It does not provide for an application. It does not provide for an application.
On merits, if I try
He can take shelter on a footing, but that lies on a different ground.
Right.
Acting a bona fide on the legal advice before a wrong forum. It is not a wrong forum.
Office has been pointed out that the delay is 254 days. And they are challenging the order passed by the Honorable Single Judge in the writ petition, not in the review. The office pointed out the defect. To which order you are challenging? They rectified the
we filed
office order and
on a good faith manner. We are here. Well, any cost your lordship may impose. I am prepared to pay the some.
Review order.
No.
No.
No, I am challenging both review and other the merit. Both. I have challenged both. Review was on ground of delay.
Review is not on delay.
Review delay control hand on merit, but I am challenging Millers.
No, against the review, rejection of your review application, have you filed? Have you challenged?
Yes,
I'm asking
I have challenged.
Where is that?
Your lordship may kindly see. Prayer Millers. Your lordship may kindly see prayer page 32.
There was stamp reporting pointed out these are the defects. They made a rectification that we are challenging the order of passed in the writ petition, not in the review.
No, Millers. Your lordship may see my prayer.
No. The prayer is there, but have you abandoned?
Yes.
I have not
Stamp
abandoned.
reporting.
I am not abandoned.
Stamp reporting.
Where do I get?
Yes, ma'am.
Oh, I'm looking at it. Limitation. Yeah. Yes. Where is he has abandoned? Where is the abandonment?
First page.
I'm looking at it.
First page. Hard copy of first page.
No abandonment.
Save it again.
Okay. First page.
Is there?
Stamp report.
It's not abundant itself. No, that is a page, stamp reporter. Anyhow, sir, when it is. Yes, this is an application for condonation of delay in since now the admission of the appeals heard.
All right, well, after the cost is deposited, I will pay.
Yes.
Right.
Deposit.
Up to that, I will pay.